Constitution, the procedure of amendment is very complicated and difficult. This does not mean that the Constitution should be legally unalterable. It simply means that the power of amending the Constitution should not remain exclusively with either the central or state governments. A constitution of a country is considered to be permanent document. It is the supreme law of the land. This supremacy of the constitution can only be maintained if the method of amendment is rigid. Authority of courts in a federal state, the legal supremacy of the constitution is essential for the existence of the federal system. The very nature of a federal state involves a division of powers between the central and state governments under the framework of the Constitution. It is therefore essential to maintain this division of powers between the two levels of governments. This must be done by some independent and impartial authority above and beyond the ordinary bodies, whether federal or state legislatures existing under the Constitution. The judiciary has in a federal polity the final power to interrupt the Constitution and guard the entrenched provisions of the Constitution. The Indian Constitution possesses all the essential characteristics of a federal constitution mentioned above. The Constitution establishes a dual polity, a system of double government with the central government at one level and the state government at the other. There is a division of powers between the central and the state governments. Each level of governments is supreme in its own sphere. The Constitution of India is written and is supreme. The provisions of the Constitution which are concerned with federal principles cannot be altered without the consent of majority of the states. The Constitution establishes a Supreme Court to decide disputes between the Union and the states, or the states interpret finally the provisions of the Constitution. But as said earlier, some scholars hesitate to characterize the Indian Constitution as truly federal because, according to them, in certain circumstances, the Constitution empowers the center to interfere in the state matters and thus places the states in a subordinate position which violates the federal principle. They therefore use such expression for it as quasi-federal unitary with federal features or federal with unitary features. In the opinion of professor, where the Constitution establishes a system of government which is almost quasi-federal, a unitary state with subsidiary federal features rather than a federal state with subsidiary unitary features. Jennings has characterized as a federal with a strong centralizing tendency. Let us now examine what are those provisions of the Constitution which are produced in support of the above argument and how to the modify the strict application of federal principle